This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland.
The button is now pressed. Thank you very much indeed. And all the members are in spotlight. We are, yes. Have we received any apologies? Pat, I know that you'll be leaving early.
No other apologies.
Nothing from Jim Wells?
Nope.
Okay, thank you. Has notice been received from any member to delegate authority to another member of the committee to vote under temporary standing orders?
When I leave, Matthew.
Okay.
Yep. I think that is.
Yep. Declaration of interest and members of any relevant financial or other interest to declare to the committee.
Chair, if I may, I should declare it's not a financial interest, it's a parliamentary assembly business interest. I am chair of the all-party group on press freedom and media sustainability, which touches on some of the issues we'll be discussing today.
Okay. Thank you. Moving on to item number 3, chairperson's business, national insurance increase. As members are aware, the House of Commons is today voting on changes to social care in England, which are to be supported by an increase in employees' national insurance contributions. The press have indicated that the corresponding unhypothecated increase in Northern Ireland's budget might be around about 400 million. Is the committee content to write to the Minister seeking clarity on the impact of Northern Ireland's budget of the national insurance increase, confirmation that budget increases will be unhypothecated, and information on other recently reported health-related budget consequentials? Are we agreed?
Agreed.
Chair, just one issue I would
go ahead.
be interested in. Probably it's not our minister who can answer that, but part of the package announced yesterday was a cap of, I think, 85 or 86,000 pounds on care payments. Is that now in the discretion of the executive as to whether they extend that cap to Northern Ireland?
That's all. It's devolved, as the members are aware. So health and social care will be devolved in Northern Ireland. So it'll be for our executive, our assembly, to decide whether we copy or not.
Good.
Okay.
Matthew?
Chair, I was going to make a suggestion either to include it in our letter to the department/minister or to write a separate letter to the Treasury to ask for clarification on a point that was included in the Prime Minister's statement yesterday, in which he seemed to imply that the Barnett consequential would effectively be hypothecated, that the health and he talked about, I don't have the verbatim quote in front of me, but he talked about there would be direct spending by the UK government on health and social care in Northern Ireland, which obviously would be quite a big change to our public spending framework, albeit there have been, the UK government has taken some legal powers through the Internal Markets Act to spend directly on what were previously devolved matters. Then subsequently there was other what seemed like clarification from the Treasury to the media. This money would be dispersed via conventional Barnett methods, but the communication was basically very unclear yesterday. So I think it would be worth our committee seeking clarification on either from the Department of Finance in the first instance or directly via the Treasury about how it came up, what the position is, and B, how the apparent uncertainty came about.
I think we should write to the Minister, because I think clarification had come from the Treasury that basically said that it was unhypothecated and there was no change in how sort of Barnett was applied to the devolved administrations. But I think it would be worthwhile just to make sure that the Minister sort of clarifies that.
Yeah.
Clarifies that clarification. But, bearing in mind, without prejudice, what the Prime Minister normally speaks and how he speaks, I think the Treasury's clarification to me, because when I read that and I thought, oh, that's a change, but then I read what came from the Treasury and it seemed to me to read as if there was no change in how it was being.
Could very well have been a bit of, as it were, topspin put in his oral statement at the last minute, but it would be worth us getting clarity from the Finance Minister about his department's view, not his view, just his view, his department's view of what happened.
Okay.
Sure, I think that's fair enough, but generally about matters which are unhypothecated, like we've had a lot of Barnett money. At some point I would like to see, for some recent financial year or period, how much of that we actually spent on a hypothecated basis and how much we squandered or spent elsewhere.
As in broken down by...
Yeah,
how they have that granularity.
What it was allocated for and how it was actually spent.
The question as well.
Yeah, we've got those.
Chair, does the committee also just want to seek clarity also on the question the member asked about the cap? I blandly stated that it was it's a devolved matter, but might be interesting.
Well, that's the question. Yeah, get the question out of here. Okay, we happy? Moving on to the next item, a spending review. Members are aware the press have indicated that the outcome of the spending review, including a reported 5% cut for Westminster departments and an anticipated multi-year budget, may be known by the end of October. The committee has already written to the Minister seeking confirmation on the key timelines and has arranged a briefing from Assembly Research later in the autumn. Would the committee be content to write to the Fiscal Council and ask it to produce a timely report on the spending review outcome and to share the findings at a public committee meeting when the report is available, which may then form the subject of a committee motion and potentially a plenary debate? And I think that sort of gives a good indication also to the Fiscal Council and the role that we expect of it going forward.
Yeah, if I may, Chair, thank you. I think that's wise. I also think the 27th of October is it's earlier than I would have expected. In previous autumn generally means 30th of November / first week in December, with a bit of sort of wiggle room around terminology. So it's 27th of October. That's actually quite early. It's also, I believe, we are in recess that week. So it does have an impact on we will be talking about the forward work programme later on this afternoon, but do we want to consider having an evidence session, possibly just from RIAs, possibly from, it could be from a think tank about about what we should be expecting and what we should be looking out for, as it were. Well, ahead of 27th, i.e. the week before.
Well, let's have a look at sort of the programme as how it evolves, and I think as the closer we get, because I think one thing we're not. Come on in, Jim. One thing we're not fully sure yet of sort of the level of the workload we're going to have is coming up to that, and sort of the timings of that. But we'll keep it under advisement, Matthew, if you're content with that.
Okay.
Okay, thank you.
Chair, could you just restate again what you're writing to the Fiscal Council for?
Yep, sorry, we're writing to the Fiscal Council to ask them to produce a timely report on the spending review when they've got it, and to share the findings at a public committee meeting when that report is available. And then that could form the subject of a committee motion and a plenary debate. Happy, Militia?
Thank you, Chair.
Okay, cheers, thanks. Moving on to the next item, Climate Change Number 2 Bill. As members will recall, the committee stage of the DERA-sponsored Climate Number 2 Bill is underway. The bill sets out a carbon budgeting system and indicates there will be associated significant capital investment costs for Northern Ireland departments and Northern Ireland industry, and agricultural as well as staffing pressures will arise for the Northern Ireland Civil Service. Is the committee content to write to the department to ask it to set out what it expects the associated costs and staffing pressures might be, and whether this will be included in the spending review outcome in the multi-year budget? If they're quoting within the DERA bill associated significant capital investments, I would hope they'd already discussed the items with the Department of Finance and other committees as well to look at any delta that would be required for additional staffing in other areas. Are we content to do that? Agreed.
Yeah.
Next item, Chair's business, ring-fence Dell underspend. If we go back, I think for members of the committee will remember, I think we were quite surprised to discover there was an issue of the Dell underspend. I think it was about 403 million, and we hadn't been kept informed of that. But then we've been told it was due to how student fees were being looked at. As members will recall of the 2021 outturn and the June monitoring round statement, the Minister indicated there was ring-fence Dell underspend of 401.9 million linked to the student loan impairment at the Department of Economy. Officials told the Finance Committee in an evidence session before summer recess that the relevant Barnett consequential of 443.8 million, which was notified to the Department of Finance on the 20th of January, post-January monitoring, was significantly higher than the 133 million pressure identified by the Department for the Economy. So it would appear that the size of the problem of a ring-fence Dell underspend was known either to the Department for the Economy or to both the Department for the Economy and the Department for Finance by early February 2021. At its meeting on the 20th of April, we considered monthly forecasts and outturn financial information provided by the Department of Finance. This showed the relevant underspend at the Department for Economy for March 21 to be 131 million and not 400 million plus, as was subsequently indicated. We raised this issue on 2 occasions, and I don't think we really got much in the way of a satisfactory answer. So I'm just asking the committee whether we're content to write to the department in order to seek an explanation as to why the department's information to the Finance Committee in respect of the substantial underspend was considerably inaccurate when information to the contrary was clearly available, i.e. in January. Are we content to do that? Agreed? Agreed. New other item on the agenda, Chair's business, new technology strategy. In a written answer, AQW 210602-17-22, the Department has indicated that it will be developing a strategy to determine how best new technology, such as artificial intelligence and robotic process automation, can support the Northern Ireland Civil Service and the delivery to the public services. Are we content to write to the Department seeking further details on the scope and timeline for the production of this new policy? I think that would be quite interesting to discover what they're doing on robotics and AI. Thank you.
Might get a robotic answer.
Probably. During the weekend, I attended the British-Irish Association, and at the British-Irish Association meeting, I know it was covered in Chatham House rules, but Paul Johnson, who is chair of the Independent Fiscal Commission, it's looking at tax raising powers, he gave a very good presentation to the association about issues to do with tax raising, to do with VAT, and some key issues that he'd already discovered that would be worthwhile. I think it would be very useful if this committee could see that presentation, because I think it was particularly helpful in understanding, and it cleared a lot of issues up for me as well. I would like, with the committee's permission, to write to Paul Johnson and ask him if he would make that presentation available. And I understand he's indicated that he would do so, but I would like to get your permission to do that if we're agreed. Great, thank you. Okay, next item, draft minutes of proceedings on the 1st of September. The draft minutes of the Finance Committee meeting on the 1st of September at the page 7. Are we content with the draft minutes? Great. No matters arising. So can I remove all the members from the spotlight and bring the research officer to the spotlight from Ray's place? I think it's Raymond, is it?
It is.
Yes, Chair, yeah.
Hi, Raymond.
Hello, Chair.
Okay. Yep. We are now receiving oral briefing from Ray's on the defamation bill. The following papers are relevant to the agenda item research paper at page 19. Raymond, over to you.
Okay, thanks, Chair. So I'll begin by really setting the context in relation to Northern Ireland in terms of where we are with defamation law and the moves in recent years to bring about change. This will focus substantially on the work of the Northern Ireland Law Commission and subsequently that of Dr. Andrew Scott, now Professor, I believe. I'll then move on to a discussion of the Defamation Act 2013 as it applies in England and Wales, which of course the Private Members Bill replicates, and I'll highlight areas of interest. The paper included information on developments in Scotland and the Republic of Ireland. I don't intend to address these during this presentation, as really the key point of reference is the Defamation Act 2013 and the associated commentary around that. Before we get into it, I suppose in terms of defining defamation, the paper contains a few different definitions, but broadly, a statement about a person is defamatory if it causes harm to the person's reputation. That is, if it tends to lower the person's reputation in the estimation of ordinary persons. So, Northern Ireland, the civil law on defamation in Northern Ireland has really developed through common law, with some aspects codified in statute. It's essentially the same as the law in England and Wales prior to the implementation of the Defamation Act in 2013. The Defamation Act of 1952 did not extend to Northern Ireland, although the subsequent Defamation Act of 1955 generally introduced the provisions of the 52 Act into Northern Ireland law. There was also the 1996 Defamation Act, and again, this mostly applied to Northern Ireland. To bring it more up to date, so attempts to reform defamation law in Northern Ireland have really gathered pace in recent years. And of course, Mr. Nesbitt had reached the consultation stage with the previous bill, but had paused his work to allow the Law Commission to examine the issue in detail. So a 2014 report from the Law Commission was followed by a report by Dr. Andrew Scott of the London School of Economics on behalf of the Department of Finance. And Mr. Nesbitt's original private members bill was included as an appendix in the Scott report. The Law Commission had concluded that there was good reason to believe that defamation law, as it was currently structured, does not best serve either the interests of the immediate parties to publication disputes or the interests of the wider public in the circulation of accurate information matters of importance. So the Scott report, which built on the work of the Law Commission, summed it up that to a significant extent, measures equivalent to the provisions of the Defamation Act 2013 should be introduced into Northern Ireland law. Specifically, this includes strong recommendations that the following provisions should be emulated, and again with consequential changes reflecting the change in jurisdiction. And that would be the defence of truth, defence of publication on a matter of public interest, qualified privilege for peer-reviewed scientific or academic statements, extension of existing qualified privileges, a single publication rule, power of court to order publication of summary of judgment, power of court to order takedown of statements, and updating the law of slander. It then went on to say that the following provisions of the Defamation Act should be emulated, although in each of these cases it considered that the argument for the introduction of the provision was less compelling. And this was the serious harm test, and then action against a person not domiciled in the UK or a member state. On this issue, this is really libel tourism. The Northern Ireland Law Commission, its original consultation paper, noted that it is difficult to identify many firm cases of libel tourism that have occurred in the Northern Irish courts, although it did surmise that such cases may have occurred. The Scott report stated that the unanimous view of all respondents to the Law Commission consultation, who explicitly addressed that point, was that such reform was desirable. So, for example, the reform was variously described as important and small but significant. And members will note that a report published under the Northern Ireland Executive Formation Act of 2019 found that in the period from 2010 to 2018, there were on average 35 Queen's Bench writs for defamation per annum, ranging from 19 in 2017 to 54 in 2010. It went on to say that report went on to say that Northern Ireland's current law provides that a claim can be summarily dismissed where no real or substantial tort has occurred, and it concluded that therefore libel tourism would not be straightforward. The third area that the Scott report said should be introduced, but where it felt there was less compelling evidence, was the presumption in favour of trial by judge alone. So the Northern Ireland Law Commission consultation paper noted the anomalous position that defamation trials alone in civil law proceedings currently involve a presumption in favour of trial by a judge with a jury. Now, a strong view among those respondents who replied specifically to that question was that the jury should be removed from defamation proceedings. It was generally thought that the continued role for the jury was a barrier to the efficient management of defamation cases, and that it negated opportunities for the early resolution of key facets of defamation proceedings. Now, set against this, the Scott report stated that the historical and constitutional importance of the jury in the Northern Ireland context should not lightly be undermined. And really to sort of bring that together, the Scott report noted that a viewpoint expressed frequently to the Northern Ireland Law Commission by those in favour of the introduction of reforms equivalent to those set out in the 2013 Act was that Northern Irish law should emulate the English legislation without any substantive change. But then the report identified a desire on the part of those who advocated this position to also go beyond that legislation to really address areas specific to Northern Ireland. And again, the report highlighted two areas where it felt Northern Ireland should not, in fact, replicate the Defamation Act 2013. This was the jurisdictional exclusion relating to secondary publishers. This is found in Section 10 of the 2013 Act, and the Scott report stated that this should not be introduced in its current form. Rather, that exclusion should be extended to prevent any defamation claim being brought against a person other than the primary author, editor, or publisher of a statement. And this would lead on to the fact that no equivalent to the defence for website operators found in Section 5 of the Defamation Act 2013 need be introduced into Northern Ireland law, and that existing defences for intermediaries can be repealed. Moving on now to the Defamation Act 2013 and turning to look at some of its key provisions. And again, bearing in mind that the Private Members Bill replicates this, so it's sort of the commentary in these clauses serves for the Private Members Bill as well. Really, the 2013 Act in England and Wales had been the culmination of pressure exerted over many years to reform law in this area. And again, one of the main concerns was the so-called practice of libel tourism. Really meaning that people could bring cases in England and Wales, even though the case had little connection to that jurisdiction, basically believing they had a better chance of winning compared to other jurisdictions. The government also recognised worries that the threat of libel proceedings might be used to frustrate robust scientific and academic debate or to impede responsible investigative journalism, and this is the so-called chilling effect. So essentially, the 2013 Act was designed to ensure that a fair balance was struck between the right to freedom of expression and the protection of reputation. So looking at some of the key provisions of the Act, Section 1 established a threshold of serious harm, whereby a statement cannot be defamatory unless the claimant can show that its publication has caused or is likely to cause serious harm to his or her reputation. And essentially, the intention of this was to deter trivial claims. It has had its critics. It has been described as the Act's most opaque, albeit well-intentioned, innovation, whose practical effect polarised legal opinion from the outset. And just to spend some more time on this, it was tested when a French resident, Bruno Lachaud, sued two British newspapers over allegations that they had printed about him. Now, the High Court rejected the newspaper's arguments that the statements were not defamatory because they did not meet the serious harm threshold in the Defamation Act. In 2017, the Court of Appeal dismissed the newspaper's appeal, and it has been argued that the incremental result of this was a 70% increase in defamation claims from 2017 to 2018. The Supreme Court found that the reference in Section 1 to a situation where the statement has caused serious harm is to the consequences of the publication, not the publication itself. Lord Sumption said that this points to some historic harm, which is shown to have actually occurred, and is a proposition of fact which can be established only by reference to the impact which the statement is shown actually to have had. So this depends not only on a combination of the inherent tendency of the words, but also their actual impact on those to whom they were communicated. So in the Supreme Court's view, the defamatory character of the statement no longer depends only on the meaning of the words and their inherent tendency to damage the claimant's reputation. And it is to that extent that Parliament intended to change the common law. Section 2 provides for the defence of truth. It renamed the common law defences of justification and fair comment as ones of truth and honest opinion, and really were intended to make the law simpler and clearer to understand and apply. Subsection 1 provides for the new defence to apply, where the defendant can show that the imputation conveyed by the statement complained of is substantially true. And that reflected the current law as established in the case of Chase versus News Group Newspapers Limited, where the Court of Appeal indicated that or found that in order for the defence of justification to be available, the defendant does not have to prove that every word he or she published was true. He or she has to establish the essential or substantial truth of the stem of the libel. So it essentially codified the prior position, and again was really intended to make the law simpler and clearer for people. Section 3 of the Act replaced common law defence of fair comment with a new defence of honest opinion. Defendant has to meet 3 conditions to be able to rely on this defence. Firstly, that the statement complained of was a statement of opinion. Secondly, that the statement complained of indicated, whether in general or specific terms, the basis of the opinion. And finally, that an honest person could have held the opinion on the basis of any fact which existed at the time the statement was published, or anything asserted to be a fact in the statement published before the statement complained of. But the defence would be defeated if the claimant can show that the defendant did not hold the opinion. Section 4 created a new public interest defence. This section provided a new statutory defence to those publishing responsibly on matters of public interest, and this built on the previous common law defence. And previous analysis of this clause found that in order to be able to rely on the defence, the defendant must show that the statement was or formed part of a statement on a matter of public interest, and that he reasonably believed that publishing the statement complained of was in the public interest. So the defence therefore contains both a subjective element, what the defendant believed was in the public interest at the time of publication, and an objective element, whether the belief was a reasonable one. Section 5, this created a new defence for the operators of websites where a defamation action is brought against them in respect of a statement posted on their website. So it provides a defence to website operators who choose to follow a process aimed at enabling a complainant to protect their reputation by resolving matters directly with the person who is responsible for the defamatory posting. Prior to the 2013 Act, a website operator hosting user-generated content could be sued in relation to defamatory content that was posted on their website. Subsection 2 provides for the defence to apply if the website operator can show that they did not post the statement on the website. However, subsection 3 provides for the defence to be defeated if the claimant can show that it was not possible for him or her to identify the person who posted the statement, that they gave the operator a notice of complaint in relation to the statement, and that the operator failed to respond to that notice in accordance with provision contained in regulations to be made by the Secretary of State. Just last year, one legal firm reported that it wasn't aware of any reported case in which Section 5 has been run at a hearing, and its experience suggested that the take-up of Section 5 procedure has been very low, and it went on to say that it viewed it as complicated and onerous, and is probably unattractive to website operators who will often have no interest in the matter and who may be able to rely on other defences. In its post-legislative memorandum on the Act, the government stated that in relation to Section 5, it is understood anecdotally that the provisions have been little used, with website operators preferring to remove material or rely on other existing defences. But the government's post-legislative memorandum goes on to state that the defence under Section 5 was introduced because of concerns at that point that operators might not have adequate protection. And if the website operator chooses not to follow the process established under the Act, the defence under Section 5 will not be available to the operator in the event that it is sued for defamation. But this doesn't impact on the availability of any other defences that may apply. The government summed up that the fact that website operators are choosing not to rely on the defence does not therefore appear to constitute a significant issue in practice. Moving on, Section 6 created a new defence of qualified privilege for peer-reviewed material in scientific or academic journals. There are two conditions attached to this. Firstly, the statement must relate to an academic or medical matter, and secondly, before the statement was published in the journal, an independent review of the statement's scientific or academic merit was carried out by the editor of the journal, and one or more persons with expertise in the scientific or academic matter concerned. However, if the publication was found to be made with malice, then the defence falls. Research from 2019 found that to date no major cases relying on this defence have been reported, a fact which may be interpreted either way vis-a-vis the efficacy of Section 6. Section 8 introduced a single publication rule, which means that, provided subsequent publications are made in a similar manner, an action against a publisher must generally be brought within a year of the first publication by that publisher. So previously, each publication of defamatory material, each hit on a website, created a new cause of action, and so publishers were potentially liable, however long after the original publication material was accessed. In its report on the draft bill, the Joint Committee recommended that the single publication rule should protect anyone who republishes the same material in a similar manner after it has been in the public domain for more than 1 year. But in response, the government said that this would significantly widen the scope of the clause, and it did not believe that it would provide adequate protection for claimants. Section 9, we've touched on the issue of libel tourism, provides that the court does not have jurisdiction to hear and determine an action to which the section applies unless it is satisfied that of all the places in which the statement complained of has been published, England and Wales is clearly the most appropriate place in which to bring an action of the statement. And just to give some more context to that, so it sets out in the explanatory memorandum the example that if a statement is published 100,000 times in Australia and only 5,000 times in England, that would be a good basis on which to conclude that the most appropriate jurisdiction to bring an action would be in Australia rather than England. Now, the explanatory memorandum did recognise that there may be other factors to take into consideration. So, for example, the amount of damage caused to a claimant's reputation in a particular jurisdiction compared to another one, the extent to which it was targeted at a readership in a particular jurisdiction, and also the likelihood of a claimant not receiving a fair hearing in a particular jurisdiction. Section 10 replaced the common law defence of innocent publication, removing the jurisdiction of courts in England and Wales to hear defamation cases against secondary publishers, unless it is not reasonably practical to bring a case against the author, editor, or publisher. And again, we touched on this earlier in the context of Northern Ireland. So it protects secondary publishers, wholesale, retail, newspaper, magazine vendors, distributors, commercial printers, libraries. The previous research did go on to note potential issues with Section 10, for example, in circumstances where it's difficult to locate the author, editor, or publisher, or where they could not be subject to court proceedings due to bankruptcy or even death. It noted that other defences, such as Section 5 of the 2013 Act, could be applicable in those circumstances. Section 11 removed the presumption on favour of trial by juries in defamation cases. Did this by amending the Senior Courts Act of 1981 and the County Courts Act of 1984 to remove libel and slander from the list of proceedings where a right to jury trial exists. Essentially, it removed or resulted in defamation cases being tried without a jury unless a court orders otherwise. In its report on the draft defamation bill, the Joint Committee supported the proposal as the presumption in favour of jury trials works against our core principles of reducing costs by promoting early resolution and to a lesser degree of improving clarity. It did, however, recommend that the circumstances in which a judge might order a trial by jury should be set out in the bill, with judicial discretion to be applied on a case-by-case basis. And the committee recommended that these circumstances should generally be limited to cases involving senior figures in public life, and ordinarily only where their public credibility is at stake. But in response, the government said that a clear majority of responses to its consultation on this point, including from members of the senior judiciary, took the view that guidelines would not be necessary. One of the issues that drove libel reform was the occurrence of several high awards by juries, which subsequently had to be reduced on appeal. And just a brief example of that, Section 11 was engaged in 2014 when Tim Yeo, then chair of the Energy and Climate Committee in the House of Commons, sued Times Newspapers Limited for articles published in the Sunday Times in June 2013 and thereafter online. Times newspapers asked that a jury be impaneled to hear the case. Mr. Justice Warby rejected their application, stating that neither party is a public authority. Mr. Yeo, whilst holding an influential position, is not in government and exercises no state power. Mr. Warby noted that Mr. Miller's QC, he was QC for Times newspapers, so his submissions do not identify any skills, knowledge, aptitudes, or other attributes likely to be possessed by a jury, which would make it better equipped than a judge to grapple with the issues that arise and may need to be tried. And I'm almost done, Chair, you'll be glad to know. Section 12 extends the power of the courts to order that a summary of its judgment be published. This power already existed in a more limited form in Section 8 of the Defamation Act 1996, whereby the court has the power to order a summary of its judgment to be published in terms agreed by the parties or determined by the court. This was in circumstances where the parties could not agree a correction or an apology. So Section 12 extends this to defamation proceedings more generally. And just a quick note at the end, going back to that post-legislative memorandum published in 2019, the UK government found that while there has inevitably been comment on developments in case law from differing perspectives, it wasn't aware of any significant overarching concerns arising from the implementation of the Act. So, Chair, that's an overview of the paper. I'll be happy to attempt to answer any questions or look further into any issues for the committee.
Thanks very much indeed, Raymond. Any questions? Matthew?
Yeah, thank you very much. Really helpful presentation. Is it... Are there any areas in which this proposed bill sharply diverges from the 2013 bill?
No, Mr. It replicates it.
It's largely a reversion to what we did not, we declined to give, or the then Minister declined to give legislative consent for in 2013.
Yes, I believe that's correct, Mr. O'Toole, yes.
When it comes to the question about libel tourism, you said that there was no, there basically wasn't, the evidence that there was significant libel tourism to Northern Ireland to take advantage of the relatively unreformed libel laws was anecdotal, but it's anecdotal but fairly strong anecdotal evidence, as in most people in the sector are fairly confident of that. Is that a fair statement?
Confident? Sorry, you just dropped the confident that it is a major issue or isn't a major issue, sorry?
Well, whether it's a major issue or not, that it happens, that there is, that it's, I suppose, whether libel tourism is a major issue depends on your view of whether it's a good thing that courts here are getting a bit of traffic, I suppose. But it is a fact that it is anecdotally it's happening. That's a fairly strong.
I think the perception that it's happening is strong. I think the statistics may not, well, relative to how many, the workload of the judiciary, but I suppose going by the Northern Ireland Executive Defamation Act published by the UK government, their view was that it wasn't a significant issue. And I know it didn't touch on Scotland for issues of time, but I think the view taken when they were proceeding with their bill was that libel tourism was a significant issue in England, but perhaps it wasn't for them either.
Sorry, Matthew, just a quick one. Could I ask, Jim has been a QC about libel tourism, and I noticed you were indicating there that there isn't a lot of libel tourism in Northern Ireland. Could you give any information you have to the committee so we'll be aware of it?
Well, I think it's at page 53 of the pack, where the figures are given. Before the 2013 Act came in, we had an average of 35 writs for defamation issued in Northern Ireland. The argument then was that once the 2013 Act made libel more difficult to pursue in England, that there would be libel tourism here. But the figures on page 53 show that in the year since 2013, the number of writs has actually fallen. It's now an average of 30. So I would be suggesting that libel tourism is a straw man in this.
Okay. Sorry, Matthew, go ahead. Sorry.
Thanks. That may be true, but whether libel tourism is happening, that doesn't, as in libel tourism meaning people, writs actively being issued, but it is certainly the case that the differential in our defamation law makes it more likely that someone can, for example, issue sternly worded correspondence to a publisher of information that they believe to be defamatory, with the threat or the implication of action based under our sterner laws.
Are they not hollow threats if they're not followed through by writs?
Well, we don't know. I suppose we don't know. My question to raise is really, is there any evidence that there is legal activity, meaning correspondence, out of court proceedings that don't involve the court at all, but greater levels of out of court settlement than in other jurisdictions? Is there any evidence for that?
I didn't come across any for the purposes of this paper, but again, that is an issue that could possibly be looked at in more detail. But obviously, the BER statistics do reflect the fact that it's not a significant issue. But I do take on board your point that there could be out of court settlements that obviously wouldn't contribute to statistics.
Okay, thanks, Jim.
Of course, out of court settlements would only arise if a writ had been issued in the first place. Isn't that right?
Yes, that's correct.
That's what brings it to
what Mr. O'Toole was trying to get at, I don't know how you would get at that sort of evidence base.
Well, no doubt Mr. Tweed will appear before us and we can ask him if he's been very busy in the writing of letters.
Is that a suggestion from a member from North Antrim that we invite him to come and give evidence?
Oh, I would have thought he would be a very suitable witness in due course. The question I wanted to ask the witness was, who are the main driving forces for this legislative change? Is it fair to say that the main driving force are the media organisations?
There was support from the media when you look at the Northern Ireland Law Commission's consultation, the Media Lawyers Association and the like. But again, I suppose really fundamentally it was born out of the work of the Law Commission, who felt that yes, it was necessary to update Northern Ireland defamation laws. And again, that was the main driver, and then subsequently followed on by the work of Dr. Scott.
But publicly, where are the cheerleaders for this legislation outside the media bubble?
I'm not aware of them, Mr. Alistair, to be honest.
I think that's.
And the second point was, do you think, or did you discern in your research that there's any chill factor from not having reform?
I didn't discern any for the purposes of this research. Again, I would caveat that by saying that's not to say it doesn't exist. It was clearly an issue for the English and Welsh legislation. To what extent that runs through the Northern Ireland bill, I'm not aware of any. It could be that the bill sponsor has more information on that.
Okay, thank you.
Okay, thanks. Keith?
Okay, thanks, and thank you, Raymond. On the last page, Raymond, if your document is 36 and it's 54 with us, I'm referring to online content, and then at the front page of the explanatory financial memorandum, take better account of the impact of the internet. How far does this, wide and narrow is that? We refer to the internet, do we go as far as Facebook, Twitter, or are we just purely internet? How far does this stretch? Based on the response by the Secretary of State.
It's on the final page of I just want to see.
Page 36 of you. 54 with us. Competence of the Assembly to legislate.
Or the competence of the Assembly to legislate.
That very last paragraph.
And how wide is that competence, are you saying, Mr.
No, how far does this bill go beyond the online? How far does that stretch? Does that stretch into Facebook, Twitter, etc., or purely websites? I'm just trying to, internet is a broad term and online is a broad term.
I'm cautious about sort of defining it, but I suppose online and would include those social media platforms. Again, I'm cautious about sort of overstepping my remit. Not straight into sort of legal advice, but on the face of it, it does seem to be that it would include those social media platforms, including the larger platforms like Facebook and Twitter.
So obviously the Secretary of State I can probably get it from the bill sponsor maybe in more detail. No, fair enough. I just wanted to clarify that. I presume the definition of online or website can be dependent on how you look at it, Raymond. That's all I have for now. Thanks.
Matthew, short one.
I just want to make the comment, but also confirm. I'm not a learned gentleman, so if I was remiss when we say out of court settlement, that obviously can apply to an issue where a writ has been issued and the parties before it reaches a judgment in court decide to settle out of court. But in broad generic terms, it can also mean a situation in which a libel lawyer advises a client to correspond with someone whom they are alleging to have made defamatory statements, and using the corpus of law, which in Northern Ireland, as we know, is stricter than in England, Wales, Scotland, and now the Republic of Ireland, and say, well, it's in your interests to settle this matter, as it were, out of court, but before we even get to issuing a writ. So I just wanted to confirm that was when I talked about out of court settlements, and we've had some instances of that recently. That's what I was referring to. I also just wanted to really briefly, the question I wanted to ask was, on the mirror image of Jim's question about people who are opposed to this bill, is anyone opposed to it who isn't in the legal fraternity or doesn't earn fees from the...
No, not that I'm really aware of, and I would emphasise again that there seemed to be broad support, certainly the people who responded to the Law Commission's work, broad support for reform of law in this area.
Okay, thanks very much, sir. Alicia?
I'm at Badger Road. Enjoyed your presentation there as well too. Very difficult to follow at times given the amount of detail within it. But in relation to the serious harm clause, and it's suggested maybe that may have been part of the reason why there was a fall in the number of liable cases in that in England and in Wales. By its inclusion within the bill here in Northern Ireland, do you feel that in some ways that might even compromise then, we'll say, for the citizens' right to defend their reputation?
I mean, I don't wish to sort of evade the question, but it's probably not a question really for me, Mr. Michu, to really delve into that. Again, that's probably one better put to the bill sponsor. I wouldn't want to get into the sort of a policy issue.
Yeah. Keep her, Margaret.
Okay. Thanks, Felicia. Thanks very much indeed. Any other questions? Okay, so Raymond, thank you very much indeed, and thank you very much indeed for your comprehensive briefing. And I think it's raised as many questions as it's answered, but thank you very much indeed for what you're doing. Okay, thank you.
Thank you, Chair. Bye.
Okay, cheers. From this particular part of the session, are there any actions we want to take forward, or are we better waiting until we've heard from Mike? Wait until we heard from Mike. Good, thank you very much indeed. And can we invite Mike to come in? Tim, we're now about to receive an oral briefing on the defamation bill from Mike Nesbitt. Come on in, Mike, please. Tim, the copy of the defamation bill and explanatory and financial memorandum as introduced is page 61, and a copy of the 2016 report on the reform of the defamation law in Northern Ireland by Professor Andrew Scott from London School of Economics is page 97. Mike, could you make your opening statement, please?
Chair, thank you very much. Can I thank you and the committee for your engagement, both members and staff. I value the opportunity to share my thinking and also to field your questions, comments and possibly even concerns. In terms of my thinking, for me it's simply this is about rights, your rights, my rights, the rights of the people we are here to represent. And as often the case with rights, we're not talking about a single absolute right. What we're talking about are a number of qualified rights that to some extent compete. In this case, two rights, one being the freedom of expression, and the other being the right to protect your reputation. And they are both qualified. In terms of freedom of expression, I've heard more than one member during my time here say you cannot walk into a crowded theatre and shout fire when there is no fire. Mm-hmm. And in terms of the qualification on protecting your reputation, it is only to protect it from untrue, unwarranted, unjustified attack. If your reputation deserves to be trashed, it will be trashed. So I guess if we think about how we communicate, it hasn't really changed since the beginning of recorded time. We have verbal and non-verbal, we draw, we write, we speak. But the media or platforms we use to disseminate our communications sometimes change radically. You know, the printing press in the 15th century and the internet in the last. And as our laws of defamation predate the invention of the internet, I think there's a prima facie case for saying we need a deep dive review of our laws. And we have had that thanks to three executive ministers. Simon Hamilton, when he was finance minister, spoke to his executive colleague David Ford, who was justice. David in turn spoke to the erstwhile Northern Ireland Law Commission, who undertook a very deep consultation resulting in Dr. Scott's report. And then that which was published, I think in June 2016, was signed off for release by Marcin Muller, who had replaced Simon as our finance minister. Now, I met the Law Commission, Judina Leslie, Chief Exec, and Dr. Scott before they began their work, and they asked me if I would pause my private member's bill on the basis that two processes running in parallel were only likely to cause confusion, and we were both attempting the same outcome of understanding. So I did. As I say, it was published in the second half of 2016. And
Mike, when did you pause your bill?
Oh, just before he began work, which would have been probably late 13 or early 14.
Okay, yeah. So, if it's not a euphemism, late 2016 was not a good time for these institutions. As we were, if not hurtling, we were certainly on a direction of travel leading to the collapse. So my PMB remained paused through the 3-year hiatus. And while I resurrected it when we came back, we then hit the pandemic and the encouragement from people like Conor Murphy only to focus our work on essential business. And while I think defamation is very, very important, I can't stretch it into that essential category. Mm-hmm. So it's only in recent weeks and months that I've advanced it, and what I've done is I've worked with the Bills team, who have made a couple of very minor technical tweaks to the bill. And I have also sought the Secretary of State's consent with regard to Clause 5, which governs the operators of websites, which takes us into telecommunications, which is a reserved matter. And the Secretary of State, I'm glad to say, on the 14th of May, said he was content to grant consent to the Assembly to give consideration to the bill. In fact, he said he welcomed the proposed bill. So that hurdle has been cleared. And as you know, it's now had its first reading, and it is scheduled, I believe, for the second reading on Tuesday. All right. At which point I hope that we will cross that bridge and the bill will come to you for scrutiny. In terms of where I think the Assembly is, I've mentioned 3 ministers, one DUP, one Alliance, one Sinn Féin, so that gives you some sense of perhaps there is a cross-party consent to the idea that we need to look at this. I have also, at the invitation of Matthew O'Toole, briefed the all-party group on press freedom and media sustainability, and there were no objections raised at that meeting. And of the 10 signatories to that APG, the 10 represent all 5 parties of the executive, plus the Greens, plus People Before Profit. The only party not represented, I think, is the TUV, but there's no imputation being drawn from me as to why that is. I'm also informed that Mr. Alistair can represent himself if need be, so I shall park that comment there. But it seems there is a cross-party support for the idea of reviewing, which is not to say that there is an agreement on the direction of travel, or to use that phrase, what success will look like. And indeed, at the end of Dr. Scott's report, there are 2 appendices. Appendix 1 is his version of a draft report, and Appendix 2 is my bill, although pre the tweaking by the Bill's office. I would also point out that the majority of respondents to the consultation favoured replicating the 2013 Defamation Act in England and Wales, and there are many advantages such as consistency in case law and also not putting unnecessary obstacles in the way of publishers to the extent that they would have to publish separate versions in GB and here. And when Lord Guy Black came here to launch my consultation paper, he was executive editor of the Telegraph Group in London, and this was the warning, one of the warnings he gave: if you go separately, you're a very, very small market, and it may be that publishers in GB will simply choose not to publish in Northern Ireland, rather to go to the time and expense of re-editing their works. A bit like the protocol, some companies might say, market's too small, I'm not going to bother. Of course, it's not just about the media, but that's where my interest began, Chair. In my time at UTV, I was involved in 3 cases. All incidentally involved politicians, and all were settled out of court with a financial settlement to the claimant. And the interesting thing to me about the way it worked was when the writ arrived, we went to the UTV boardroom, and you had the production team responsible for the broadcast, senior management, UTV's lawyers, but there were 2 other people in the room who had flown in from London, and they would sit quietly in the corner and listen to the arguments, the whys and wherefores. And then on every occasion, they said, settle it out of court. We do not want you taking the risk of going into court, losing the case, and a jury
awarding a disproportionate sum of money to the claimant. These two gentlemen were the insurers. So they are the ones who call the shots. And I would draw you to, I think it's item 1.05 in Dr. Scott's report, where he says, the key imbalance in this area is arguably not that in favour of reputation over free speech or vice versa, but rather that between litigants who can afford to defend or to vindicate their reputations and those who cannot. The key imbalance is who can afford to pay for these things. So I have 12 policy objectives in the EFM. I won't rehearse them all, Chair, but they include making it easier and less expensive to take legal action and make it harder for the rich and influential to chill free speech. Also to protect the right of journalists to conduct responsible and necessary investigations. If we think about this jurisdiction as opposed to, say, Dublin or London, scrutiny of government in Dublin and London comes in three ways. There's an official opposition. There's also a second revising chamber, as this Senate once was, the Seanad in Dublin, House of Lords in London, and the media. But currently in Northern Ireland, we only have one of those three prongs, and that is the media. And I wonder how often the media have not published because they have received a threatening legal letter. And we simply can't compile those statistics. So how big a chill factor does the current regime have? I'm also intending to protect the rights of scientists and academics to engage in debate. A school friend of mine, now retired, established a global reputation for his knowledge of epilepsy and pregnancy. And at one point, he became convinced that there was a certain drug that a pregnant woman should not take. But that drug was manufactured by a global pharma company. Huge resource and money and capacity to take him to court. Now, under these proposals, if what he wants to say is peer-reviewed, then it effectively becomes privileged and he can publish. That protection applies to academics in England and Wales. And again, we don't know how many academics working in medicine and science are not applying for jobs at Queen's or Ulster University because of that chill factor. But we do know there is the imbalance between here and England and Wales.
Mike, sir, when you're talking about, obviously, when academics and peer-reviewed, and it's interesting because there's a definition of what qualifies as peer review. What's your perspective on that? Because obviously one of the things that, particularly in England, it has to be with one of particular journals or a particular idea. But there is what I would call quite a lot of pseudo-academic stuff that is out there at the moment that would not meet the requirement of peer review, but would be seen by some people to be representing academic freedom. How would we get over that point, or would we look at to take the same sort of journals that are already being mentioned in England and Wales to be able to cover that?
Well, I think you start with the qualifications of the person conducting the peer review and what experience and expertise that they're bringing to the table. But clearly that's an area where you could go to court and challenge the validity of the peer review process and those conducting the peer review. And again, I think you build up a kind of case law which would suggest where the parameters are in terms of dealing with those things.
Okay.
Just to finish off, Chair, one other area is, as I say, the internet, and the clause 5, which was beyond our competence until the Secretary of State gave us permission, is with regard to reputations are trashed, not on a daily or even hourly basis on the internet, it's minute by minute. Somewhere in the world is having their reputation trashed. So my proposal in clause 5 is that if you feel you've been defamed, and you're the claimant or potential claimant, the operator of the site must give you the identity of the author who posted the site, and that by identity I mean the contact details so you can pursue them in court. And if they cannot or will not do that, you then go for the operator of the site. So you have a clear path to rectify and protect your reputation in those cases. And beyond that, effectively, what the bill intends to do is basically to update, modernise the laws of defamation. So, for example, Currently we have common law and we have justification of fair comment. I'm suggesting we replace those with statutory defences of truth and honest opinion. And my final thought is, I think over the period that the English law from 2013 has been operating, it hasn't been as seismic in terms of its impact as opponents perhaps thought it would be. So I will leave it there, Chair, but what I would ask of the committee is that they support it coming through the second stage as a matter of principle, and then very happy that your committee go through line by line and perhaps recommend amendments for further down the process.
Okay, thanks very much indeed, Mike. Thanks, and thanks for presenting to the committee. Just a quick one. We've heard a lot about sort of the English process and the rest of it. So why can't we accept a legislative consent measure that comes across to be able to do it, to update as to where we get to the 2013 position? Why are we looking for separate legislation here?
Well, as I understand it, the Finance Minister 2013 decided not to recommend a legislative consent motion.
Yeah. Have we any indication from, if you had any correspondence or anything from Conor, that he would indicate that he might take a slightly different view than the previous Finance Minister?
No. I have had correspondence from the Finance Minister saying he is not supportive of this bill. It is my impression that he has made reference in his letter to the fact that the administration in Dublin is looking at their laws of defamation with a clear inference that he's perhaps looking for an all-Ireland solution.
Oh. Okay. Thanks very much today. Pat?
Thanks, Chair. Thanks, Michael, for coming and giving the presentation. My question is simple. I suppose it's answered in a way, and I'm going right back down through a lot of the figures. I'm going to the 98th European Convention on Human Rights, which was then written into the 2013 Act in England. I'm not looking at anything specific in that, but the situation then in England was perceived to have a chilling effect on the freedom of expression. What you're trying to do is give more openness to the freedom of expression, but also protecting the rights of who is stating that or putting that out there. I mean, I'm very interested, that's one point, but I'm also very interested. I mean, there's a lot which would come out of what you're doing. I was thinking of small claim courts within just car accidents coming through there, where it's nearly impossible you could pass the insurers in order to defend your good name. That would give stronger protection to those who state the fact, or if there is a prosecution or libel set out against them. Am I reading that right?
Yes, yes, you are. And I suppose a change that I should have mentioned was in the definition.
Yes.
This idea of you have to prove that you have been subjected to or are likely to be subjected to serious harm because of the statement. So at the moment, as you know, basically the test is, would a reasonable right-thinking person think less of the complainant because of the statement?
Yeah.
And you know, referring back to the 3 cases I was involved in, which involved politicians, I have no doubt that if the test had been serious harm, that UTV would have contested and would have won those cases, rather than having to put a sum of money on the table to make it go away.
Okay, and just on the back of that, I'm looking forward to when you get to for second reading, and then it comes forward to ourselves in the committee. So, thank you.
Thank you very much. Jim?
Yeah, a few questions, Mike.
Oh, sorry, Jim Wells first.
Oh, sorry.
Ben Clever, Jim.
I was waiting.
Over the last month, I've been called a dinosaur, a monster, or a bigot. Perhaps the worst of all was I was accused of wearing a wig. Now, you can call me a bigot or a dinosaur, but anybody accusing me of wearing a wig will definitely be hearing from my solicitor. But being a wee bit more serious, certainly we wouldn't say Matthew O'Toole's wearing a wig anyhow. You couldn't buy that hair.
Steady, we're not doing defamation in this committee.
I've got privilege.
Yes.
I'm not going to issue a writ.
I've got privilege. I can say anything I like about that red hair. But I've been more serious about it. Every day in life, I am subjected to online abuse, which I think if I was minded to, I could regularly go to court. But I've only done it twice. One was a case when my wife was terribly ill with a stroke in hospital. Somebody put online that he hoped my wife would die a long, painful and lingering death. which I took great exception to. It was on a social media company based in California that has 3 billion users, not any more specific than that. And why the case is still 3.5 years later, still mired in the mud, is that company is refusing to release the identity of the person who posted the comment. Now, we know it is, but they're refusing to confirm the name of the person. How would your bill, and I mean the vast bulk of libel will be from now on will be on social media. You know, it's definitely going to become the dominant feature on these platforms. How on earth could your bill compel one of the largest companies in the world to change a policy of non-disclosure?
Well, I suppose the bottom line, Jim, is that it can't, but what it can do is say, this is your legal statutory duty to disclose the identity of the author of the post. But enforcement, it's very hard, I think, to legislate for enforcement.
But then, if none of these companies were prepared to name the person who made the untrue allegation or the dreadfully and offensive allegation, how does your bill succeed? Because this probably is going to, in the future, cover 90% of the potential claims.
Well, all I can say is it better to have the current regime, which places no legal obligation on that company, or to have this bill put into law, which does place an obligation upon them?
But if they're not based within the UK, indeed not within the EU, is there any provision in any form of legal sanction that can be used to force them to do this? There's freedom of speech, by the way, was the defence that this major company used. That it was in order for this gentleman to make this comment because that was his right to have that freedom of speech. Is there any way around that?
Yeah. Not that I'm aware of.
That's disappointing, but I can understand. Thank you.
Okay, thanks, Jim. Thanks very much today. Keith.
Yeah, thanks. And just, I suppose, to follow on, Mike, from Jim's point, just for, I suppose, a bit of clarity, I'm not going to drill into this too deep. The definition of operators of websites and your response from the Secretary of State, e.g. that large company in California and other large companies like it, does that cover them? 100%. So the definition of website covers those big companies?
Yes.
Are they websites?
They're operators of websites.
Okay, so the large Facebooks, Twitters, etc., are websites. As long as this covers that,
yes.
That's your understanding.
Yeah, and sorry, okay. Keith, could also say, yeah. I mean, it's kind of like a reverse to the point Jim's making, because there's this idea of what they call libel tourism. So, if some famous person in America, is defamed,
yeah.
And they want to do it here in Belfast, if it's been viewed, say, 1,000 times in Northern Ireland, but 2 million times in New York State, and you do it in New York State, you don't have the locust to come here.
And then this final point, this I can't just see it in front of here, this definition of serious harm. And I don't want to get into Jim's case, but, define serious harm. So if I'm getting online abuse every night, it's annoying me, it bugs me, is that serious harm? I'm not trying to dig it, is that a court case for serious harm if somebody's giving you, as people would refer to sometimes in Northern Ireland, bad manners, but you don't mind political debate online, but there's bad manners, so how do you define that that's not causing you serious harm?
Well, for example, if that was happening and it was really getting to you, you might seek medical support, and so a statement to
clarify the definition of serious harm.
Yeah.
Okay.
Thanks. Matthew?
Thank you. I want to go back to one of the points I raised around not libel tourism, so but the chilling effect that this has. It's right to say, would you do, and this is something you have explored. I mean, you've been obviously involved in this now for the best part of a decade. That in Northern Ireland it is uniquely, not uniquely possible, but disproportionately sort of more than in other jurisdictions on these islands, certainly more than in England and Wales, certainly possible for someone to use the threat of the threat of proceedings because, to go back to your experience with UTV, there is a record of there being, first of all, an unreformed legal framework, but also high costs being awarded. So there is a high prospect of a chilling factor. Is that something you've been told about or heard about, and sort of as you've been proceeding with this over the last few years?
Yes, but the problem I have is that I can't quantify it.
Yeah.
I have no idea how many lawyers are issuing these sort of threatening letters, or how often they do it. But I am aware. I mean, there's an old journalistic phrase when you're learning the trade: "If in doubt, leave it out."
Yeah.
Mm-hmm.
And this kind of takes that to a very serious place, mm-hmm. because it may be responsible and necessary journalism to say I should be publishing this, but you don't have the defences that this bill would offer. You don't currently have those defences.
So it's fair to say that not that media law in Northern Ireland is a Wild West, but it's certainly a more, in relative terms, a lawyer who has a record of getting, from their perspective, good outcomes for their clients, are able to say to their clients, I can't, you don't even need to, we may not even need to issue a writ. We can issue a sternly worded letter and then have a conversation with a raised eyebrow, and that will be sufficient.
Yeah. I think that's a fair thing to say. The other issue, I think, which is a chill factor, is the fact that it is a jury trial, and as I understand it from my experience, all the judge will do is make an initial judgment as whether the statement is capable of being interpreted as defamatory. He will not say it is defamatory out of respect for the jury's role. So he will allow the trial to begin on the basis that it can be interpreted as defamatory. And then if the jury decide it is, there is no guideline for the quantum that they can award in compensation. So you can understand why the insurers are saying, well, we won't cover you because, we think this is a 50 grand case. But a jury may say it's £500,000.
Is there a particular challenge as well around the fact that their media here, as in locally, not indigenous, but as it were, media that are primarily based here? You mentioned the Daily Telegraph earlier on, but they are they're publishing primarily, in some cases, effectively exclusively for consumption inside Northern Ireland. Obviously, with the online, where that changes and content can be consumed anywhere, but primarily the Belfast Telegraph, the Irish News, the newsletter are still publishing primarily for consumption here inside this jurisdiction, which means that proportionately it's obviously much less likely that someone is going to issue proceedings against them in London. So is there an added disproportionate burden on them than there would be, for example, for a UK publisher? If you see what I mean, because they're, the fact of a relatively unreformed defamation regime in Northern Ireland is unlikely. I mean, you talked about the potential sort of, it being a less attractive place for content, people being just not sending their content in some ways to Northern Ireland, but not publishing it for consumption in Northern Ireland because it's there's greater risk. But it's actually, the real issue is less about the Times of London or the Telegraph, or for that matter the Irish Times, publishing content here. It's about the Belfast Telegraph and the Irish News feeling that the disproportionate burden on them is one that is different than it would be for the Manchester Evening News or the...
Mm-hmm. Let me put it this way. If you say you were flying from Belfast to London,
yeah,
you might buy a Belfast Telegraph at the city airport,
yeah,
which has no mention of a leading respected scientist saying pregnant women should not use this drug. And then when you land at Heathrow, you may find that the Daily Telegraph has a front page splash saying pregnant women should not take this drug. That in sort of crude terms is the impact.
Well, on the point about you said the Finance Minister had sort of implied that there might be, that he wanted to see something, a more kind of all Ireland approach. I mean, I presume that the government in the South is pledged to look again at but I mean, it is still it's a further step along the road to defamation reform than Northern Ireland is, because it legislated about 12 years ago or something. I mean, there's no, I'm right to say that in passing this legislation, there's nothing then stopping a review or something down the line if the Republic changes its law and there are any issues. I mean, I'm not aware of any potential issues there could be in terms of all-island publications or cross-border publications, it seems. Mm-hmm. I'm just interested in understanding what his particular concern would be. I don't really...
Well, I suppose the way I would see it, in an ideal world, this bill will go through before the end of this mandate, potentially amended due to considerations and recommendations from yourselves. But then two things could happen. There could be a review of the 2013 Act by Westminster, who may come forward with some amendments, which we would simply migrate across by way of a legislative consent motion. Yeah. The second thing, and they're not exclusive, is that the government in Dublin could come out with a reform of their laws of defamation, and we may look at that and say, well, actually, there's some of that which we should be incorporating into ours, so we will amend.
But there's no suggestion at the minute that there has been the differential between defamation law provision north and south has chilled publications, the cross-border publication of material as yet. It's not.
No, I have to say I am not an expert on the Republic's laws of defamation.
Yeah. Mm-hmm. I'm intrigued to understand what the answers.
Okay, thanks, Matthew. Jim.
Yeah, Mike, you talked about when Lord Black launched your consultation. He spoke about the possible chill factor of companies choosing not to publish here because our libel laws were different. Has that actually happened?
I'm not aware of any evidence of that having happened. Sorry, which is why I said I don't think the impact of the 2013 law has been as significant as some feared.
What is it about our present system that's broken?
Well, I gave you 3 examples of being involved in defamation cases, where in at least 2 cases, I believe there were good grounds to fight against the complainant. And it wasn't a legal judgment as to whether we fought it or not. It was a financial judgment.
But you're still going to have financial judgment. You're still going to have insurance companies.
You're still going to have an insurance company, but they may be persuaded that the test of serious harm is more likely to yield a positive result for their client.
So you see serious harm, the introduction of the threshold of serious harm, as something that will help defendants and diminish the chances of plaintiffs?
Not necessarily. I think it will be a more honest and balanced approach rather than the one identified by Dr. Scott.
The example you gave of 3 politicians successfully suing UTV.
I said 3 politicians were involved.
Right, okay. In 3 cases where there are successful outcomes from the plaintiff's point of view against UTV, you would see a purpose of this bill in a repetition of such cases resulting in a successful outcome for the defendants.
In 2 of the cases, because would the public, right-thinking, ordinary members of the public think less of the politician because of the statement? I believe the answer is clearly not.
But that was the jury question in those cases. That would have been the jury question.
It would have been.
Yeah.
And the insurers were not prepared to let it go.
So your answer from the motivation of insurers putting pressure on defendants is to raise the bar for plaintiffs so that they now have to show not just that their reputation has been harmed, but there has been serious harm.
I don't think it raises the bar. I think it changes the definition, changes
Well,
the
serious
test.
means anything. It surely raises the bar.
I just believe it is a different test. And
Well,
if
the
you
test-
if you think about what Mr. Buchanan said, if you were seeing on your smartphone every night abusive message after abusive message, and it was adversely impacting on your mental health and well-being, I think it would be very easy to prove that that was causing serious harm.
No, but the law at the moment is that if your reputation is harmed, in other words, if the man in the street would think less of you because of what was said about you, then you have passed the threshold for libel or slander. And therefore, you have demonstrated harm to your reputation. By inserting the subjective test of serious harm, you inevitably are weeding out a number of cases and, in consequence, pushing the bar that bit higher for a case to get off the ground.
Well, I will respect your opinion. I'm not sure I'm entirely in tune with you, but I think probably where we might be in agreement is I think it does make it easier to weed out trivial claims.
Does that mean then that a consequence of your bill would be that you would take away from the county court any jurisdiction in defamation?
No. I think it's the limit £30,000.
No, the limit in libel is £3,000.
£3,000. I would actually.
Justice Minister has a consultation out to raise it to 10, but it's still £3,000. Now, if to bring any case you have to go show serious harm, well, then it's hard to imagine why the county court with a limit of £3,000 would even be in the picture.
Well, I'm sorry, yes, it is £3,000. I would not object to it being raised to £30,000. I think one of the things to do is to make the whole process more user-friendly, which is why I have a proposal that unless in exceptional circumstances that we do away with jury trials. And I know that in this jurisdiction that's a particularly sensitive issue. But as you would know, when we come, for example, to the single meaning rule, a judge will not define what the single meaning rule is because he has a jury and he feels it's up to, or she feels it's up to the jury to define the single meaning. So Dr. Scott uses the example of a businessman, I think, paying tax. And if you were to read that this businessman was very good at avoiding tax, you could take a very negative imputation that he's a bit of a scoundrel involved in illegal tax evasion. But equally, you might say, well, actually what that means is he's very, very good at managing his tax bill, and what he does is he donates to charity and gets tax relief on that, and this is very pleasing to the shareholders. But if you do away with the jury, there's no bar then on the judge defining the single meaning right up front, which could really speed up.
Well, in fact, you're doing much more than that. You're handing to the judge the determination of whether the harm is serious or not.
Yes.
So a judge, and some people think that judges get a bit aloof from real life, will decide whether or not someone who feels sufficiently exercised to have brought the case and to have taken the financial risk in bringing it, because there's no legal aid in defamation, that a person is going to be told by a judge, you didn't suffer serious harm, end of case. So you're taking away from the citizen the right to put before his peers or a court the question that his reputation has been diminished by sifting it through a judge's view of what is serious harm and what isn't. That may not be very confidence building with the individual who's been overwhelmed by what he thinks is quite a dastardly thing to have said about him.
Well, that judgment has to be made, whether it's by the judge or by the jury. And it is my clear impression that under the current regime, where it's done by a jury, it is a much longer and more expensive process. And as you say, legal aid isn't available.
Yes, but I'm not sure actually the costs issue. I don't think this proceeding will make it any cheaper to either defend or to bring proceedings. But the great chill factor in anyone bringing libel proceedings is the potential costs. That isn't going to be changed by this. Costs are still going to be astronomical if you lose.
Costs will still be high. I think where it might change would be in a successful case, because as I've said, as I understand it, the jury are not even particularly advised on the quantum.
Well, they're given a general sort of ballpark arrangement.
So if the judges are the ones deciding on the quantum, you might see more consistency in the awards.
But just on that point, if the system is broken, can you point us to any cases in recent years where there's been an outrageous decision in Northern Ireland out of our current system?
I'm not aware of one, but I haven't been studying the application.
I was trying to think of that myself, and I can't think of any that you would say, wow, that's way off beam.
Yeah.
Now, if that's the case, then it brings me back to one of my first questions. Is the system broken?
Well, to answer that, I would feel that I would need to know about the out-of-court settlements. How often, why, and the quantums.
Yes, but your bill isn't going to either pry or change that, is it?
I believe that it will, in that you're changing the test.
Which brings us back to the point that the test is now tilted more in favour of the defendant, of the media company, because that will give them the courage to fight. In other words, they wouldn't have fought, which does raise with me the fundamental question from the perception of the citizen. Well, why are we in the business of drafting legislation that makes life easier for the media companies?
But it also makes life, I would contend, easier for politicians.
How's that?
I've given you an example of the 3 cases, all of which involve politicians. In 2 cases, the politician was the claimant, and in both cases, the insurers were responsible for them being offered a financial settlement.
But those insurers, I'm going to make the point again, those insurers will still be saying to you, it's cheaper to settle than to fight if you lose.
Well, I think it changes the test, because what those insurers were saying was that if the judge says this is capable of being interpreted as a defamation, he will initiate the trial and he will hand over control to a jury over which we corporately have no control. And if they find in favour...
Who's the we?
Well, the lawyers, the broadcasters, the jury are autonomous.
Yeah.
And if they find for the claimant, there's very little control over the quantum that they could award. So it goes back to point 105 of Andrew Scott's report. So what I'm saying is, if it is a judge without a jury, right up front, he doesn't say this is capable of being interpreted or not. He says it is or it isn't defamatory.
Well, it does or does not give rise to serious harm. That's what he says, isn't it? Yeah.
It's only defamatory if it has or is likely to cause serious harm.
Serious harm is a filter to filter out cases. Which brings me back to the point that this legislation is about diminishing the opportunity of the citizen to bring a claim, because he has to get past a judge who says, okay, you suffered harm, but it wasn't serious harm. Go away home and pull yourself together, man.
Yeah, well, you're defining it as diminishing. I'm defining it as offering something fairer.
Fairer for whom?
Sorry?
Fairer for whom?
For everybody.
Not for the man who's told the harm you suffered wasn't serious.
Well, what if the harm he or she suffered was not serious?
But is that not the point of libel damages? That they then relate to the degree of the harm. If the harm isn't serious, then they might get 1p or £10 or £100. Because damages reflect the seriousness of the harm. So if the harm isn't serious, they're not going to get a big award, are they?
That may be the case.
If the system's working, that should be the case.
Well, I contend the system is capable of improvement.
But there's no examples in the last number of years of where the system got it badly wrong.
In terms of the quantum?
In terms of the quantum, or even a finding of libel.
Well, I have not studied every defamation case, and as I've said, one of the reasons for that is it's what's happening behind the scenes. The out-of-court settlements, which we cannot trap in terms of a statistical analysis, but which I suspect is very significant.
Which you can never control.
Yeah.
People have all sorts of reasons for settling cases. They don't want to be named, they don't want to have the bother, etc., etc. They want to keep their legal bill down. You know, this legislation isn't necessarily going to change that.
Well, I think it will, for example, if you are a scientist or you are a researcher in medicine and you really want to make a statement which is critical to, for example, a multinational pharma company, that this gives you protections you do not currently have in terms of...
And that gives you privilege.
Yeah, it gives you peer-reviewed privilege.
Yeah. I think actually, I have a reasonably open mind on this bill, but I certainly have a lot more sympathy for the point you're making about the privilege than about the serious harm. I think that's my big stumbling block with this bill. But thank you. Oh, yes.
Can I say, I mean, you're the lawyer. To what degree do you think it is possible to codify serious harm?
I don't think it really is possible. I think each case rests on its own facts. I don't think you can really have an open and free legal process whereby the citizen is entitled to come to court and have his rights judged if you put into it a bar where a judge decides whether or not it's serious harm or not. I think that's a problem in terms of open access. I assume, Mike, you'll amend Clause 9, which still keeps us in the EU.
Read that in.
Through the chair. No, we won't. Right. Okay, thanks, Jim. Philip?
Thank you. Thanks, Mike, for your presentation. I don't intend to interrogate you quite as vociferously as Jim just did, but in terms of Jim's line of questioning, it kind of reinforces my opinion that I was surprised that the second reading is next week, given that we haven't, as a committee, had an opportunity to talk to department officials or even the minister in terms of their position on the bill. I mean, I know you've received correspondence from the minister and you've given your own interpretation of that correspondence to us today. So it would have been useful, given the kind of questioning and indeed some of the speculation that we're going over here today, because a lot of this is actually speculation. I mean, you're pointing to 3 examples that none of us sitting here can be confident one way or the other that any different legislation would have changed either the outcome or the decision to take to court. It's all purely speculation on your part, and I'm not sure that us formulating and designing legislation based on speculation is the right way to go about it. I mean, lots of people have asked questions about the libel tourism. We got the opportunity to ask the same questions earlier during the Ray's presentation. So, I mean, in terms of libel tourism that has been talked about, I mean, the simple reality is that it hasn't increased since 2013, and anything over above that is just speculation. in terms of the point you did make about the minister and the review of legislation in the south, well, that's not just in terms of all Ireland approach, which personally I think would be sensible. I don't know if that's what the minister meant in his response, but I still think it would be sensible. It's not something that Andrew Scott would disagree with, because he did say that the North needed specific legislation to reform libel law. So I think that in itself would be sensible, that we look at jurisdictions on this island and beyond to see what kind of specific legislation we've made. You talked about publications from GB that also publish here, but the same argument is on the south-north basis. So, I think that we do, I would agree with Andrew Scott in terms of specific legislation, and I think that that's something we do look at. But in terms of my points, just in terms of the libel tourism, because I don't think it was, that question was specifically asked you, can you confirm that it hasn't increased since 2013? And then the other issue that you touched on, and Jim previously touched on, was the jury trial. Obviously, removing jury trials here in the North could be seen as a backward step and a threat to the principles of the right to a fair trial and access to justice. So, would you accept that jury trials play an important role in public confidence in our legal system?
Yeah, on the latter point first, yes, I do, and I think I acknowledge that jury trials have a particular resonance and significance in this jurisdiction. For reasons we don't need to rehearse. In terms of the timing, could I say that I got my first reading, I think it was in early June. There was then a decision to be made as to whether I press for the second reading before summer recess. Not least, and the advantage of that was, once we get back next week, we're expecting the final months a lot of legislation to come out of the executive. So there's a danger of losing the bill, even if it does get through its second stage next week, and I make no assumption on that. So the decision I made was, because I have been living this for a while, but you haven't, as a collective of MLAs, that I would wait until after recess, and that what I would do after the first reading was to compose a one-pager, which I put in everybody's pigeonholes, and which I believe my office also emailed to all the MLA accounts, just to give that kind of top-line indication, not only of that the bill was coming, but that what the policy objectives and the intent was. So maybe it's not ideal, but I'm sitting here thinking, hallelujah, I'm discussing defamation with a committee for the first time since 2014. All I'm asking is that we have a debate on Tuesday, and that you allow it to come back to committee. And what happens after then, who knows? And I'm not a die in the ditch, take it or leave it. I'm more than happy that we look at everything, and that this idea that maybe serious harm is not the best definition to put in the bill. Let's talk it. Let's talk it through.
Yeah, but you've obviously on Assembly committees and have been the chair of Assembly committees. In terms of us doing our role, even for the debate on Tuesday, but just doing our role in the committee, it would have been, or it would be better if we had all the arguments and allowed all the participants to come before us and give evidence.
Yes, but in June, as I say, I put a one-pager in your pigeonhole offering to meet any MLA, any group, any party to discuss. And one party did take up the offer and had about half a dozen people in the room, and we talked it through for a couple of hours.
Yeah, but I'm specifically talking about the department having had their opportunity to come before the committee and give their view on the legislation.
The second stage.
I can't answer for the department. I know I was asked if I would come and speak to this committee ahead of the second reading, and I'm very happy to do so.
Okay.
Okay, Philip. Anybody else? Okay, Mike. Any other comments from the committee? Okay, Mike.
Thanks
very much today. Thank you. Okay, thank you very much indeed, members, and thank you very much indeed for listening through the evidence and the evidence we had that came through from Raise as well. First of all, are there any specific actions we would like to wish to take forward? I understand. Philip, do you want to come in again? Obviously, we haven't heard from the minister. And as chairman, I wasn't aware of the fact that the second reading was going to take place next week, and I don't think Peter was either.
I don't think we knew that yet, Chairperson.
And I don't think the business committee's actually sat, so I'm not quite sure where that information came from. So that I understand where your comments coming from, Philip, but I'm as blindsided as you are in this with the timing as well. And obviously it would be useful if we got the Minister's view and perspective of the department on this bill, because obviously Mike is talking about his correspondence with it, but we haven't heard from the department either yet. So it might be useful if we wrote to the department to get his view. Sorry, go ahead, Jim.
Chair, I must say I disagree. Tuesday, if it is Tuesday, is a vote on the principles of the bill.
Yeah.
And surely that's for each and every MLA and their parties to reach a view on. Mm-hmm. I don't think any of us should be coming to this coloured by what a particular department thinks.
No, sorry, I probably got that the wrong way around. What I was trying to do is, there's part of this information we haven't received yet, which was what was the department's view on it. I don't think that if it comes before us that's a different question if it comes before us in the second stage. That's quite right.
Custom and practice, as I understand these committees, is that the bill sponsor is given an opportunity, it's not a necessity, to come before a committee before a second reading as a general educational process. Mm-hmm. But that I've never known of a case where other evidence is heard
before the second stage. Okay. I'm just trying to remember.
Correct me if I'm wrong, but I don't.
You're just referring to your bill. No, we didn't. We didn't hear second stage. Okay. Any other comments? Okay, team. Obviously, depending on when the second stage goes ahead, does anybody wish to give an indication how they might vote in respect to the second stage of the defamation bill? Or are we going to? Okay. Therefore, are members content for me to contribute to the second stage debate, indicating that the committee is probably supportive of its passage to the committee stage of the bill?
Whoa.
Chair.
Yeah, go ahead, Philip.
I mean, that's the point that's the point I was trying to make. I mean, maybe I'm wrong in terms of procedure and who comes, but I mean, certainly, in any debate or argument, I like to hear all the arguments before I give my opinion. And in this case, what I heard from Mike, as I said, a lot of it was conjecture. I mean, I didn't think he particularly convinced me when Jim Allister was questioning him. So fair play to Jim in terms of that. So, I mean, a lot of it was just supposition, conjecture. I mean, I don't think any of us have any problem. I mean, I certainly don't have any problem with the theoretical view that we could have updated libel legislation, but the key point is whether this is the way to do it, and that's why I would have liked to have had departmental officials to come forward to say, why. I mean, because the only thing that we got out today was that the minister has written to Mike to say that he couldn't support this bill. I would like to know what the reasoning behind that was, to help inform me make up my mind. So, I mean, I wouldn't, personally speaking, that's allow the committee to have an opinion, because I don't think we have. I mean, I'm going to have to think personally myself, if it is between now and Monday, what my opinion is.
Yeah, well, if I can say that actually at the second stage. Actually, you don't even have to speak at all if it comes in front of the second stage.
Look, I think the only thing that be said on behalf of the committee is that the committee heard from the bill sponsor. And
I think that's about as far as we can go. Yeah. I think I'm not saying anything contrary to that. Okay, content. So I'll speak at the bill whenever it comes to the second stage, whenever it comes forward, and just say that we heard from the bill sponsor, and they said there was a varying set of views expressed at the meeting, and I'll leave it at that. I think it would also be probably useful, and again, I think we should write to the minister anyhow, just to get his views on the bill, because I think that would be useful, so that we would have that as a committee. And I think that would be useful. Go ahead, Matthew.
Presumably we're not going to have that for
Tuesday?
No, not before Tuesday. I mean, look, we're speculating that it is Tuesday. That's the problem I have no information that it is going to be Tuesday or not. So, but I think we should be writing to the minister anyhow because it is a bill that's coming before us. We've had this, and it'd be worthy of us getting the view of the Minister and the Department on it. Are we agreed? Agreed. Agreed. Excellent, thank you. Next item was that the committee, I think when Paul Frew was in the committee had suggested a change to standing orders which would allow a bill sponsor to join a statutory committee as an ex officio member in order to allow the speedy resolution of queries during the committee stage. The committee has asked to note that the Committee on Procedures has yet to advise on any relevant change to standing orders and is very unlikely to do so during the anticipated committee stage of the bill. Are we content to note?
Mr. Chairman,
go ahead, Jim.
that came about as a result of the very helpful input from Jim
Yeah.
and his bill, which frankly would be floundering without his input. But what is there anything to stop us as a committee inviting whoever we like to sit in on committee meetings and ask them questions?
Chairperson, to advise, in terms of the bill sponsor, what the committee could do is they can invite any other MLA along, but they are not allowed to question witnesses, and of course they're not allowed to vote.
Yep.
But what members might be able to do, and I'm seeking advice on this, is that, Mike, if there was a committee stage, and that gets through second stage, the bill sponsor could sit in, if members agreed, and make comments to the chairperson, and the chairperson could then say, well, witness, what do you think to that? So it is a bit of a swizz, bit of a cheat, but I'm seeking advice on whether that is acceptable.
If we can take this separately, so we can myself and the deputy chair will discuss that.
Take that forward.
Yeah, take it.
But Chair, there's no restriction in the number of times this committee hears evidence from the sponsor.
Absolutely right, absolutely right. Yeah. And it would probably be a good idea to encourage the bill sponsor to come along. What we would typically do with the department is you might have 2 or 3 evidence sessions with witnesses, have the department come in last, and then answer all of the questions that were raised during these previous evidence sessions, if the bill sponsor and his helpers were able to do so. So you can certainly do it that way, which is clean and clearer.
What happens to, sorry, for my own education, what happens to other bill sponsors who are not members of a particular committee bringing it forward? But Jim, you were on our committee, so that
I've been through this before. My first bill, I wasn't on the committee. I gave a presentation like this before the second stage. I then gave formal evidence, and I was brought in the committee stage, and I was allowed to come back to respond at the end of the committee stage, as I recall.
Could you listen in? Were you present when the evidence was being taken?
Only if I listened in. It was my option. It was a public.
Yeah, it's public.
Unlike now, you could come in and sit. So I did.
Right. Okay.
Quite often. Yeah.
Okay. Thanks. Okay. Thank you. Moving on to the next item on the agenda is correspondence. Correspondence index. The members asked to note index of 8 received items. Thank goodness. On correspondence from page 200. The first one is EU Regulation 2021-414. Members are asked to note at page 204 a copy of the correspondence between the House of Lords Subcommittee on the Northern Ireland Protocol and Treasury, seeking clarity on the impact on Northern Ireland businesses' engagement with the Executive in respect of EU Regulation 2021-414. The regulation pertains to electronic systems for the exchange and storage of import-export information. Treasury seems to indicate that the Trader Support Service will advise Northern Ireland businesses, and that changes may follow UK government discussions with the EU on the protocol. Consideration was this deferred from last week. The correspondence now includes the explanatory memorandum and the missing appendices. The correspondence appears to indicate that no executive departments commented on the correspondence. Jim, would you like to say something?
I think I made that point last week.
Yeah.
I've tabled a number of questions to relevant departments asking them why.
Matthew, okay, Matthew.
Well, I just think it makes the case actually something we might have to crave, hopefully, agreement on at some stage, that the necessity for better consensus on how we regularise information sharing and scrutiny of these matters.
Just for a note of information, conversations I've had over the last couple of days outside the committee, but might pertain to this. There was a considerable amount of discussion about one of the difficulties that's now being received about gathering of information and the difficulty of actually understanding and getting the necessary information that there is. And one of the main issues by a couple of members of the sort of the business community was that there is a considerable amount of detail of information that's available through sort of trading systems, logistics systems and the rest of it. But the problem is that it doesn't speak to the HMRC system or the other data systems, and the two IT systems are incompatible. The words used to me that one is in the 21st century and the other is probably still in the Stone Age when it comes to talking to each other. I think there might be a real data adequacy issue that might be involved in this as well. So it might be something we might take consideration when we're taking more evidence on the protocol, and I think we're doing that next week. Yeah. Okay. Thank you. Next, just to say, are members content to write to the Executive Office, copying the Department for Finance and other statutory committees, and ask why departments didn't provide any commentary on the regulations? Is the committee content to also ask the TEO to set out the scrutiny process for any future EU regulations, and to suggest that relevant statutory committees be kept advised, as would usually be the case for Westminster statutory instruments which touch upon devolved matters? Are we agreed?
Yeah.
Excellent. Moving on to the report of the Department of Finance Equality Scheme. Members are asked to also note at page 217 a copy of the Department's report on the Equality Commission on the Department of Finance Equality Scheme and Section 75 duties in 2021. The report details actions the Department has taken, amongst other things, to increase employment in the NICS of young people and minority groups. In AQWs, the Department advises the number of 16 to 24-year-olds has increased in percentage terms quite significantly very recently, and other measures are planned. Matthew, would you like to say something about that?
Just, I mean, it's welcome that the number of under 24s, obviously, is a bit of a crisis we're facing in the civil service. It's something that we should, I think, keep under consideration. We've talked about getting evidence from the head of civil service, HR, and the new head of the civil service. I think we should be asking them about this and what specific plans they have in place to address the age profile question.
Okay. Is the committee content to note, pending the briefing on the 3rd of November by... Sorry, Jim.
Sure, I just wanted to make a comment. Not many others might agree, but I notice at page 227 of the pack that the department has again renewed its Stonewall membership and has submitted itself essentially to Stonewall, marking its homework in terms of diversity in the Stonewall Diversity Championing Programme. I'm also conscious that across the water, the Equalities Minister has advised government departments to quit the Diversity Championings Programme, that the GB Human Rights Commission has quit the programme, all because of the campaigning controversial stances of Stonewall, particularly in relation to transgender issues. And yet here we are tying ourselves to an organisation which has gone out of its way to, I think, create controversy on some equality issues because of the rigid agenda that they stick to. And I don't find it pleasing that the department is blindly re-engaged. You know, the Stonewall recently in a report said that freedom of speech is all very fine, but it has its limits, and challenged the people for daring to hold a view that you cannot change your biological gender, and described that as akin to anti-Semitism. And it's for reasons like that across the water there's been a distancing from the overtly campaigning Stonewall and acknowledging them as the diversity champion.
Yes, I would be very supportive of Jim's views. Stonewall is a very radical, extreme organisation which is entirely biased in one direction, entirely opposed to those who hold a different view, a traditional view on family and gender. And I'm alarmed at the amount of public money that's been poured into it in Northern Ireland from many organisations. And therefore, I notice, for instance, the police, PSNI, are giving them considerable funding, which seems way beyond anything that they warrant. I think in times of very difficult constraints financially, this is a waste of money. An ego trip by one or two senior executives in the department. And I don't think it should continue. I don't think it's needed. And I totally support Jim's comments.
Thank you. Sorry, go ahead, Matthew.
Well, I think I think it would be remiss of me not to respond in very strong terms to what's been said by the two previous speakers, particularly because the historic context is, of course, that Northern Ireland has consistently failed its LGBT plus community in terms of delivering on basic levels of equality enjoyed by other citizens in not just the UK but the Republic of Ireland. So I would strongly disagree with the foregoing comments. I welcome that some measure of attention is being given inside the Northern Ireland Civil Service to ensuring that we are not just meeting our obligations, but properly promoting and championing diversity and equality in the civil service, and long may it continue, and long may it improve, should I say, because we're still have progress to make.
Okay. Any other comments?
Yes, to the Chair.
Alicia.
Exactly what Matthew has said there. I think that particularly in Northern Ireland, because of many of the prejudices that I'd expect my full support again too for the LGBT community and that as well too. And every effort that's made then within organisations as well too to ensure that equality, which is the right of all citizens, is respected.
Okay, thank you, Alicia. I think there's a variety of views there and the rest of it, but duly noted. Move on to the next item on the agenda, a review of the Department of Finance Equality Scheme. Members are asked to consider at page 280 correspondence from the Department seeking the Committee's views as part of its review of its equality scheme. A copy of the current equality scheme is appended. Are members content to write and inform the Department that it expects the Department to forward its findings from stakeholders when received? And at that stage, the committee will consider the equality scheme. It's better to see what they say first before we get involved. Are we agreed? Great. Special Advisor Annual Report. Members are asked to note departmental correspondence at page 328, including the Special Advisor Annual Report. Under the Civil Service Special Advisors Act Northern Ireland 2013, the Minister is obliged to lay a report indicating the number of SPADs and their salary. This has been delayed owing to changes in the DUP team. Anybody wish to comment?
Chair, I think it's good to have, well, I would say this, I think it's good to have the report, but one thing that puzzled me about it, when you look at page 330.
Hold on one second, Jim.
Sorry, I've got the wrong page. Give me a second. At page 332, though the average salary of a SPAD has dropped by £10,000 since 5 years ago, the annual salary bill has increased by 10%, roughly. I didn't quite understand. Is that increased pension contributions, maybe, or I don't know.
Was it due to the fact that some of them had to be laid off? Does it include?
Does it include? Well, that wouldn't be a salary bill. That would be a. I would presume that would be, those costs would be separate.
Right to the department. See.
Well, we do know in the column above that the raw salary figure is 876, the national insurance is 103, and the pension contributions are 285. I was just puzzled how, if the salary scales, if the average salary is down 10,000, how the bill for salaries is increasing.
What period of time did that kick in, the salary?
Well, obviously when they came back on whatever date it was in January.
2021.
Mm-hmm.
Well, it's
That salary bill's 2021.
Yeah.
I think it would be worthy if we ask the question for a bit of clarity on it.
Don't think it'd do any harm.
Agreed.
I think we're agreed, a bit of question of clarity. Excellent. Thank you. Okay, next item, the Gender Reform of Property Management Programme. Members are asked to consider at page 333 a response from the Northern Ireland Audit Office indicating that the introduction of hard charging is a key property management control, and one which, if introduced across the Office estate, would foster commercial style discipline. The Controller and Auditor General describes the Department's explanation for its apparent U-turn on this matter as not very convincing. Thank you, Kieran. Excellent.
Understatement.
Is the committee content to write to the Minister and seek his views on his department's decision to backtrack on previous commitments made to the Audit Office? I think we would be agreed to that. We're agreed. Excellent. Moving on to investment activity report. Members are asked to note page 341, the latest investing activity report. The department has a limited capital programme which is largely restricted to refurbishment and support of the reform of property management programme. Are we content to note?
Okay.
Content. Yep. Next item is civil service pension retirement provisions. Members are asked to note page 344 a departmental response regarding the extent of partial retirement in the Northern Ireland Civil Service. There is a markedly higher percentage of Northern Ireland Civil Service staff that are partially retired compared to the Home Civil Service, even though the level of eligibility in Northern Ireland is lower. Jim, would you?
Well, I raised this before at a previous meeting. I'm happy enough to let it sit at the minute.
Okay.
I'm not going to raise any the hairs on it. I am in a slightly difficult position being chair of the pension trustees here that I don't say anything too controversial.
Okay. Are we content to note? Anybody? Sorry, Matthew.
Well, I am content to note, but I also think we should be sort of putting a bookmark in this for our conversation with Nick CHR later in the autumn, because as we discussed before, 2,000 partial retirees is, as we know, getting on for 10% of the entire civil service workforce. 1,500 is, I suppose, 7 or 8%. Therefore, I don't think, unless I've missed it, I don't know if you said the whole civil service. You don't make, but we don't know what a comparable number would be in the UK civil service, or for that matter in another big public sector employer. So I think it's a question we should be going back and asking to Nick CHR when we talk to them.
Yeah, I just think the committee seems to be, if we look over the years, it seems to be growing. It seems to have become nearly a management tool in some respects, or senior management of going on sort of partial retirement and then sort of staying for a few days and whatever the procedure happens to be. It has now become sort of nearly like custom and practice.
More a sinecure tool, I think. Maybe that's harsh, but
Could they introduce it for
I would disagree with that, Sir Mr. Ellis. I couldn't possibly say that.
Most of them are not, and obviously most people, but it would look to be most of them aren't at SCS or even middle management level. They're very much at the sort of lower to middle / administrative grades. So that it wouldn't suggest that there's a huge amount of people who are being sinicured off in cushy jobs. But there is I'm less concerned about that, but I do still think it's an interesting question to ask about workforce management and whether this fits into a broader picture around age profile and all that.
And also there's a question I think we do put to next HR when they come, because the question of somebody is in a role for 3 days a week or is in partial retirement, does that block that as an opportunity for promotion? Or does it move it? Does it in some way or another sort of reduce the flow of staffing as required? But are we content to note and raise this issue? Sorry, go ahead.
Am I misunderstanding something? On page 344, it says partially retired numbers 2018, and then when you go to page 348, it tells you 1,529 of those are in what we would regard as the regular lower grades. Does that mean that 500 of them are in senior grades?
Mm-hmm.
Is that a fair interpretation of that?
I think it's a question we'll ask when we get the next HR in front of us.
But that actually doesn't make sense because it says 10 senior civil servants.
I don't know.
But then,
why is that?
But then you look at sort of grade 6, grade 7s.
Yeah, and senior grade it says 10. So where's how do they reconcile 1,500 to 2,000? Where's the reconciliation?
I think, Chairperson, if the member looks at page 347, it's 1,529 is the total number of people currently working in reshaped jobs. This is out of a total 2,029 partial retirees from a number of employers administered by the civil service pensions. So one refers to the civil service and the other refers to other organisations which come under the civil service umbrella, I guess, or the civil service pensions umbrella.
For the arm's length bodies.
So
My understanding would be the 2029 refers to people who are who could potentially do reshape jobs. They have the status of being partially retired, and that 1529 is the number of people who are actually working in
no, the 2029 are the actually partially retired, because that's what it says. It's the 1529, I think, are the civil servants. That's what I'm taking it to mean.
Yeah, but what I mean is that we won't be talking cross purposes, but the 1529 is included in the 202.
Yes.
Yes. Yeah.
And and those are the people who are actually going in and doing a reshape job, whereas the remaining 500 are presumably not doing reshape jobs. They're just on the books as partially retired.
No, they're in arm's length bodies, maybe, or something.
Yeah.
Like that.
Oh right.
Yeah.
Okay.
I think the member's right.
Maybe
That's
that's
how I would read that.
Fine. Okay, that might be
Could we maybe ask for a breakdown of that 500 in terms of arm's length bodies?
Agreed, Chair.
Yep. Content?
Yep.
Great. Okay, thank you. Move on to item 9 on ministerial correspondence. We just need to be cautious when we talk of this. Members are asked to also note on page 356, restricted ministerial correspondence, providing an update on the RHI disciplinary process. It appears that one individual in the senior civil service, i.e. grade 5 or above, was subject to sanction. The other 7 cases considered by the Northern Ireland Civil Service and the 2 cases that we have been briefed about, considered by the Cabinet Office, did not lead to any other sanctions for various reasons. Are we content to note this pending the closed session briefing on the 29th of September? I'm surprised actually we got that correspondence as we did, but noted. Okay. Moving on. Sorry. Militia, did you say something?
Yeah, we're content to note it.
Okay, thanks. Moving on to the composite request, members are asked to consider the composite request on page 358. Members content the composite request is an accurate and complete record of the committee's information requests. Are we agreed?
Right.
Yeah.
Good. Okay. Moving on to the forward work programme. Draft forward work programme is page 365. Legislative consent motion. Department has led a legislative consent motion relating to the Public Services Pension and Judicial Offices Bill. The Clerk has circulated related papers by email. Briefings from the Department, Assembly Research and Public Sector Unions are scheduled for the 22nd of September. Are we content to publish the relevant papers on the committee's webpage? Agreed. Financial Reporting Bill. The committee stage of the Financial Reporting Bill began before the summer. The committee launched a call for evidence. A small number of responses have been received. Very few have been substantive. The committee staff are to follow up with key stakeholders. A SharePoint folder will be established so that members can view all of the responses. In the meantime, as is usual, is the committee content to share the responses with the department and publish them on the committee webpage?
Great.
Are we agreed? Yep. Excellent, thank you. Are members content with the forward work programme as amended?
Great.
Agreed.
Can I just say,
go ahead.
We had just on next week's hearing. This is the first we've seen of who's actually that I've seen, unless it's been of who's going to be attending next week, or was this drawn from a long list of?
Sorry, I don't
the next week's hearings.
Yes.
Just because we didn't have that, I don't think we had the named witnesses. We've got the RHA and the UFU.
You want the names of the witnesses?
No, not the names of the witnesses. I just wasn't. I don't think the names of the organisations was in.
I think we had NI protocol expert. It might have been in last week.
I don't think it was I suppose it was just a kind of a couple of questions. That we're going to have them at the same time, and one other thought was the RHA are obviously do lots of interesting organisations, but it might be worth us also having Freight NI, who have a kind of view of the whole logistics, including freight forwarders, and so that would be my suggestion. I'm happy to.
I think chairperson.
I think they were on someone from Freight Logistics NI or Freight NI, as they're called. Were in the were on our initial list, and we.
Hold on, let me tell you exactly who's coming from RHA, from the Road Haulage Association. It's, if this opens, come on yourselves, mind the gap, here we go, it's, no, that's wrong, sorry, the organisations are, goodness sake, is Gray and Adams and Target Transport, as well as I can't remember the name of the chap from RHA. They're coming along. So
They're members of they're
Yes.
companies. They're okay.
Yeah.
They're haulage companies who are members of RHA rather than just the RHA corporately.
that's
Yeah.
right. The RHA corporate, they are coming along as well.
Okay.
So they are the Northern Ireland sort of branch there of John Martin, I think, is their policy manager. So they'll be along. So I would suggest, members, that it's going to be 2 briefings. First from RHI, we give them 15 minutes to make their point, and then members can ask questions for a further 45 or so. Then UFU. 15 minutes again, 10 to 15 minutes, and then another 45 minutes for
Who's
members.
coming from the UFU?
It's not Victor Chestnut. We were trying to get him, but apparently he's in London. So it's, let me tell you, it is not here. Maybe it is. Sorry, members. This will all become very clear on Friday when it's in the meeting pack out. But for now, no, sorry, don't have it. I'll have to send you.
Okay.
Because I don't have that in front of me right now. But it isn't. We were trying to get Victor, but I think he has another engagement. I think it might be their policy lead will be come along to speak to us. Yeah, it's James McCluggage.
There's a big Northern Ireland event next week in London. I think
Right.
it might be on the Wednesday. The business community and selling Northern Ireland, so he might be at that.
So it's their policy lead, I think, is Mr. McCluggage.
Yeah.
Used to be in DERA, if I recall correctly.
Yeah.
So, yeah, and another. So that's planned for next week.
Okay, if we're happy, content with the forward work programme?
Yep.
Excellent. Any other business? Good. Date and time of the next meeting. The next meeting will take place here Wednesday, the 15th of September at 1400. Thank you very much indeed. The meeting is hereby adjourned.
This is the Northern Ireland Assembly Senate Chamber programme signed. This is the Northern Ireland Assembly Senate Chamber programme signed. This is the Northern Ireland Assembly Senate Chamber programme signed. This is the Northern Ireland Assembly Senate Chamber programme signed. This is the Northern Ireland Assembly Senate Chamber programme signed. This is the Northern Ireland Assembly Senate Chamber programme signed.